Let's talk about grand jury minutes and inspection of the grand jury minutes in federal court and in state court. In state court, if you've been in New York, you have a felony, if you've ever been to court for a New York felony charge at the arraignment or maybe on the day after the arraignment, every single lawyer without fail says requesting inspection of the grand jury minutes, or they do it in their motion practice. In federal court, it's not a thing. Federal grand juries enjoy this very heavy presumption of secrecy, and you do not get to break this presumption of secrecy unless you as the defense counsel could make a showing that there was something wrong in the grand jury presentation. And it can't just be a guess that you're making. You need to show to the judge, whether it's a mag judge or a district court judge, that there was something really messed up in the grand jury. And you need to identify what this thing was to get the judge to lift the grand jury secrecy and actually look at the minutes. In state court, it happens on the regular. I think it's almost malpractice if the lawyer is not asking for the inspection of the grand jury minutes. And our clients who we have federal cases with have a difficult time understanding, to the point that I have to print out the Supreme Court case that explains this, that there is no inspection of the grand jury minutes in the feds unless there is an issue that's identified. And in the state, this is like an everyday thing. So if you're coming from federal practice to state court practice, something for you to keep in mind: always ask for the inspection of the grand jury minutes on the state unless you're running the speedy trial clock. And it's really not a thing in the feds, because the federal grand jury minutes, unless they're Brady, are considered 3500 material, and you don't get them until like the very end of the case.